Welcome to the deep dive. Today we're heading straight into a really high-stakes situation in Juba, South Sudan. It's this major legal and political drama playing out right now. We're focusing on the ongoing treason trial involving the suspended first vice president, Dr. Machar, and 7 others accused alongside him.
Absolutely. And this isn't just some minor political issue. I mean, this trial could genuinely reshape the country's political landscape. The charges are incredibly serious. We're talking treason, crimes against humanity, mass murder, even terrorism.
Wow. And it all circles back to that incident in March 2025, right? The attacks on the army base in Nasir County.
Exactly. That's the core event. It tragically led to the death of General Majur Dak. And, the prosecution is pointing the finger directly at Machar's group, the SPLM-AIO, and the White Army militia, they say, are allied with them.
Okay, so the stakes are clearly enormous. But for this deep dive, we want to zoom in on what happened just recently during the 8th court session. That was October 8th at Freedom Hall.
Yes, that session was critical. It wasn't just about new evidence being presented, though that happened. It really blew up because of the fundamental constitutional arguments that evidence immediately sparked.
Right, so our mission today is really to unpack that. How the rules, the procedures are suddenly threatening this whole high-profile case.
Precisely. It's a fascinating look at legal process versus political reality.
Okay, let's get into it then. The prosecution came in strong, didn't they? They had new exhibits.
They did 4 documentary exhibits and 2 physical items. Now, the judge, James Deng, he provisionally admitted them.
Provisionally, meaning?
Meaning, kind of temporarily accepted, but the defense immediately raised objections. Strong objections about how this evidence was actually obtained.
Gotcha. And it sounds like the prosecution's case leans heavily on electronic stuff, communications, data.
It really does. That seems to be the core. The first set of documents they brought in were all about the process of getting that data. There was a letter from the National Communications Authority dated September 5th, and alongside that, 2 ministerial orders from the Ministry of Justice.
Okay, orders for what exactly?
Well, one authorized the actual extraction of data from devices, and the other basically approved using that extracted data as evidence in court.
So the official paperwork, seemingly, but what about the actual technical evidence itself? What did they show?
Right, the payload, as you called it earlier, well, quite a bit. First, there was a report from the National Security Service, the NSS. This report detailed a radio signal device they claim is linked directly to Dr. Machar's communications.
A radio device. Okay, what else?
Then they presented flash drives. These supposedly contain audio and video recordings from the Nasir incident itself, and also a physical notebook. This notebook apparently contains communication logs.
That sounds like potentially very sensitive material. And then there were the physical items that really kicked things off.
Yes, exactly. That's where the big legal fight erupted. They submitted a Samsung mobile phone and a MacBook laptop. And the prosecution stated outright that these devices belonged to Dr. Machar.
Okay, so phone, laptop, logs, recordings. And the defense immediately saw an issue with the authorization papers.
They did. As soon as those ministerial orders were presented, the defense zeroed in on the dates.
The timeline.
Why was a timeline such a big deal? You mentioned September 1st and September 5th.
Precisely. The defense lawyer stood up and pointed out something pretty significant. The entire case, the formal charges against Machar and the others, had already been sent to the court on September 1st.
Okay.
But these crucial ministerial orders, the ones giving permission to extract and use the electronic evidence, they weren't issued until September 5th, 4 days after the case was already underway in court.
Ah, I see. So the argument is they got the permission after they technically needed it, once the court process had started. Exactly. The defense basically called it a huge red flag. They argued it undermines the whole procedural integrity of how the evidence was gathered. Did they get permission retroactively?
That does sound procedurally messy, to say the least.
It raises serious questions. Did the security services follow the proper legal steps before the case officially opened? But, that was just the first line of attack, the procedural one. Then they hit them with a constitutional argument. This focused on the evidence itself, especially those devices, the phone and the laptop.
Right, and this is where Article 22 comes in. That's the core of their argument now.
Absolutely. They shifted from the dates on the documents to the fundamental rights involved. They argued that seizing that phone and laptop violates Article 22 of the South Sudanese Constitution.
And just remind us, what does Article 22 protect?
It guarantees every person's right to privacy. It's meant to be a shield against the state just, snooping without cause or proper procedure. So the defense's claim is very direct. These items, the phone, the laptop, the technical stuff, were obtained illegally.
Illegally how?
Because, they argue, there was no proper judicial warrant. And the way they were seized didn't follow the rules set out in the Criminal Procedure Act of 2008.
Okay, the 2008 Act. So that law basically says you need a judge's permission based on actual suspicion before you can just take someone's private phone or computer.
That's the essence of it, yes. It's there to make sure investigations don't just trample over fundamental rights. It sets out the proper steps for search and seizure.
So if the defense is right, if those steps were violated, what happens in a huge trial like this? Does the evidence get thrown out?
Well, that's the crucial question, isn't it? In many legal systems, yes. Evidence obtained improperly, what they sometimes call fruit of the poisonous tree, is inadmissible. It doesn't matter how incriminating it might seem. If you didn't follow the law to get it, you can't use it in court. The defense is essentially asking Judge Dang to exclude all this technical evidence. They're saying the Constitution was breached, and that's that.
Wow. That really is state security versus individual rights playing out right there in the courtroom. How did the judge react to this immediate challenge about the phone and the laptop?
Judge Dang took a cautious approach. He didn't rule on it right away. Instead, he basically paused that decision. He postponed ruling on whether the devices are admissible or not.
Postponed until when? What's he waiting for?
He's waiting for testimony from a forensic expert, someone who can analyze the data that was supposedly extracted from the phone and laptop.
Ah, okay, so he wants an expert to look at how the data was pulled off the devices first.
Seems like it. He wants that technical analysis before he makes a decision on the constitutional question. It's like he's saying, let's see what the experts say about the data itself and how it was accessed before I rule on whether the seizure was legal.
So it's fascinating. The fate of this key evidence, maybe the whole prosecution case, might not even depend on what's on the phone.
Exactly. It might depend entirely on whether the proper procedures under the 2008 Act were followed when they seized it. The process could end up being more important than the content.
That's a major hurdle for the prosecution.
A huge one. The court is clearly taking the constitutional challenge very seriously.
Okay, so while all this legal debate about how the evidence was gathered is going on, the court is also hearing two totally different stories about what actually happened at Nasir back in March.
Yes, and these competing narratives are politically charged, to say the least. Remember the prosecution's third exhibit?
That was the military report.
Right. Signed by General Santino Deng Akat of the SSPDF, the government army. And that report paints a pretty standard picture. Government troops had to evacuate the base because it was overrun by hostile forces.
Meaning the SPLM-IO and their allies, according to the prosecution. A straightforward attack narrative.
Pretty much. But then the defense comes back with something completely different. A counter-narrative that just flips the whole thing on its head. They claimed that the evacuation effort that followed the incident, including recovering the bodies of General Majur Dak and a UN staff member who also sadly died,
Yep.
The defense claims that whole operation wasn't a reaction to an attack by their side.
So what do they say it was?
They argue that the entire coordination, the recovery of the bodies, the evacuation, was actually orchestrated by Dr. Machar himself.
Machar orchestrated it, but he's the one accused of ordering the attack.
Exactly. That's the bombshell.
Yeah.
And they go further. They claim he did this coordination with the full knowledge and implicitly the agreement of President Salva Kiir
President? Yeah.
and the cabinet
Yeah.
and UNMISS, the UN mission there,
Yeah.
and even the peace agreement guarantors, all the major players.
Hold on. If Machar was coordinating a humanitarian and security response with the president and the UN?
It makes the accusation that he was simultaneously masterminding a treasonous attack seem, well, contradictory, doesn't it? It severely undermines the prosecution's narrative.
That puts the judge in an incredibly difficult position. He has a military report saying attack, and the defense saying, no, it was coordinated recovery at the highest level.
It forces the court to weigh these completely opposing accounts. One is a military viewpoint. The other involves high-level political interactions during a crisis. It's not just about facts on the ground, but who was talking to whom.
Yeah, that moves beyond just legal argument into some really complex political territory.
Absolutely. The court has to somehow navigate that.
Okay, shifting slightly. Amidst all this high drama, there were a couple of smaller, more human moments in the proceedings.
There were, yes. It showed a bit of flexibility. The defense team, for instance, was given an hour to visit the 7 co-accused. They're being held at the National Security Service's Blue House facility.
Which is known for being quite notorious, right?
It has that reputation, yes.
Yeah.
And it was noted that 3 of those 7 had only recently been moved there, so the visit was probably important.
And there was also leave granted for one of the accused.
Yes, Gatwich Lampooch. He was given temporary leave for a very personal reason to offer condolences after a death in his family.
It's a small thing, maybe, but it does show the court acknowledging the human side, even in a trial this politically charged.
I think so. Yeah. It suggests the judicial process is still trying to function with some standard procedures and compassion, despite the immense pressure.
Okay, but the main focus remains the legal battle. Judge Deng adjourned the court. What's the next key date?
Monday, October 13th. That date is absolutely crucial
Why so critical?
because that's when the forensic experts are expected to testify. Their analysis, what they found on those devices and how they think the data was accessed, that's going to be the pivot point.
So their testimony could decide whether the phone and laptop evidence is even allowed.
It very likely will. If the experts say the data extraction looks dodgy, or if the judge ultimately agrees the initial seizure violated Article 22 in the 2008 Act, then potentially the prosecution's main technical evidence just disappears.
Wow. The whole case could unravel based on that expert testimony and the judge's ruling on procedure.
It really could. It highlights how central this electronic evidence is to their case.
So let's try and summarize this for listeners trying to grasp the significance here. On one side, you've got the prosecution. They have technical reports, radio logs, military accounts, all aimed at proving treason.
A very serious set of accusations backed by what they claim is concrete evidence.
But on the other side, the defense isn't just arguing the facts of the Nasir incident. They're making a stand on fundamental rights. They're saying, look, the Constitution guarantees privacy. The law dictates how you collect evidence. You have to follow the rules, especially in a case this big.
Exactly. It's become a battle over the process as much as the alleged crime. It's about authorization dates, warrants, and the letter of the law, specifically the Criminal Procedure Act of 2008.
So it's incredible, really. We're talking about charges like treason, mass murder, but the whole thing might actually turn on whether a mobile phone was seized with the right piece of paper?
That's the potential aha moment here, isn't it? For anyone watching how the rule of law develops, particularly in challenging contexts like South Sudan, it shows that judiciary might be pushing back, asserting its role in making sure even the security services have to operate within legal boundaries.
So the outcome might not be about guilt or innocence based on the content of the data, but about the legality of how it was obtained.
It could very well come down to that, a technical ruling on the admissibility of evidence, rather than a judgment on the underlying political accusations. And maybe the final thought for you, the listener, is this. What does it tell us about the real balance of power when a court case against a top political figure hinges on procedural rules protecting citizen rights, potentially overriding national security arguments? Where does that balance lie?
That's a really powerful question to think about. As we wait for October 13th and that expert testimony, we will definitely keep following this. Thanks for joining us on the Deep Dive.